respondent, my learned junior appellant, Mr. Momin Khan, will cover both the grounds and myself, beginning with the first one. Would Your Honor like me to reiterate the facts of our current case, or should I begin with my submissions?
Yes, please, if you can briefly.
Okay.
Yes.
My client, Mr. Payne, is an avid user of the online cryptocurrency trading program, Cleverday, and this program uses a currency called YAPL and algorithmic programming, which allows users to automatically make trades through the programs of their own creation. My client had one such program called Beta. This program allowed the users to sell YAPL at a price based on the average price. However, if no other users were offering to sell YAPL, Beta automatically offered it for sale at an inflated price. The defendant, Ms. Rani, also had one such program, Alpha, which is designed to buy YAPL at the best possible price available. On June 10, 2022, when both parties were sleeping, Cleverday glitched and excluded all users below the cash margin of $200,000 instead of the usual $50,000. For 30 minutes of the glitch, the only users on the platform were Ms. Rani and Mr. Payne. Their programs Alpha and Beta concluded a trade of 100 YAPL, which I will be referring to as the disputed trade, at a price 250 times the prevailing market price. Cleverday recorded the trade and debited $250,000 from Ms. Rani's account to Mr. Payne's. Ms. Rani issued proceedings in the DIFC Court's Digital Economy Court seeking a declaration for a unilateral mistake, and my client, Mr. Payne, issued an application challenging DIFC jurisdiction. It must be noted that the judge at first instance dismissed both the claims on the grounds that firstly, DIFC courts have jurisdiction under Article 5A1 subsection B of Dubai Law number 12 of 2004, which I will be disputing. The first ground of my appeal is that the previous judge erred in law when stating that DIFC courts do have jurisdiction over the claim of Ms. Rasrani. To begin with, the rules of the DIFC courts 58.76 states that a party who objects to the court's jurisdiction to decide a claim or a counterclaim shall not be taken to have accepted the court's jurisdiction simply because they also defend the substance of the claim or counterclaim. This applies that, since Mr. Payne was defending the fact that a mistake had not been made, he did not accept the DIFC jurisdiction and should not be made to do so. Also, due to the fact that cryptocurrency is a relatively new topic in the field of law, the cases are quite limited. However, one of the major cases was that of Alibaba Group Holdings Limited versus Alibaba Bitcoin Foundation number 1872897. For the benefit of the court, may I reiterate the facts of the case?
No, thank you, counsel.
Moving on with this case, the defendant argued that the court lacked personal jurisdiction over it because ICO sales did not occur in the US. And since the transactions consist of ledger entries made in Minsk, Belarus, and other jurisdictions in the world, following observation of changes in blockchain data outside the United States. And due to the decentralized nature of cryptocurrency, it would be impossible to pin jurisdiction to one location. Ledger entries, as previously stated, are recorded in multiple nodes worldwide, and therefore to settle on one jurisdiction simply due to the existence of a node in that location could cause several clashes of jurisdiction. It can be argued that a single user that deals with online trades across the globe can then potentially claim for jurisdiction in any one of the widespread locations of the nodes. I would also like to cite the case of Gautama Shipping Limited versus Ghazi Shipping and Logistics and Geffen FCCO, case number 48 held in the DIFC Small Claims Tribunal in the year 2016. Would the court benefit with the facts of the case, or should I move on with my submission?
Yes, please, if you can share the facts.
The facts revolve around the claimants who alleged that the defendants failed to clear 16 of the 20 containers from the Jebel Ali ports that they were contracted to do so. This failure resulted in significant detention and port storage fees being charged against the containers. On 11 April 2016, the claimant filed a claim in the DIFC Court's Small Claims Tribunal for reimbursement of the charges required to clear and return the remaining containers. The claimant claimed a total of $113,696 against the defendants. Both of the defendants responded to the claim by contesting the jurisdiction of the DIFC courts over the dispute. In this case, it was seen that as the parties are not DIFC entities and the agreements at issue were not performed or meant to be performed within the DIFC, there was no claim for jurisdiction. Therefore, the claimant's claim was dismissed as the DIFC courts lacked jurisdiction over the matter. Similarly, the blockchain node simply being in the DIFC area does not appoint it as a DIFC entity at all. If that were the case, then any node in any location worldwide would automatically become an entity of their surrounding area, rather than one single link in a larger network chain, what exactly a distributed ledger of crypto is. This would create many difficulties when interpreting the reach of a single node, as well as determining the area that a single node would represent would be tireless work. Moreover, according to Article 5A2 of the Judicial Authority Law, it is possible for the parties to agree in writing to the jurisdiction of the DIFC courts after the dispute arose. However, in our case, the parties failed to do so. The appellant contested jurisdiction of the DIFC courts, and as this is considered a rejection to an opt-in of the DIFC court's jurisdiction. Therefore, as none of the relevant jurisdictional gateways of the judicial authority law apply to this case, it falls outside of the jurisdiction of the DIFC courts. Similarly, in our case, due to the appellant contesting jurisdiction of the DIFC court, the opt-in system of the DIFC cannot be applied as both parties have simply not agreed to do so. This is further reiterated by the case of Mindali versus Moon, case number 396 of the DIFC Small Claims Tribunal in the year 2020. Would Your Honor prefer a summary of the facts of the case?
No, if you can share what was just concluded.
In this case, the judge held that the claim was dismissed due to the lack of jurisdiction, as the DIFC courts can exercise its jurisdiction over a matter that is unrelated to the DIFC only where the parties have agreed in writing that any dispute arising between them would be referred to the DIFC courts for adjudication. In our present case, the matter must be deemed unrelated to the DIFC, as already established before, a single node cannot be enough to determine jurisdiction, and also because the parties have not agreed in writing to settle this matter. There is no possible way to claim for DIFC jurisdiction. Further emphasizing the previous point on the decentralized nature of cryptocurrency, Torkin Main's article titled Blockchain Opportunities and Legal Considerations, published on 20th April 2022, states that, theoretically, a given transaction could be governed by the applicable law in any jurisdiction where there is a node. Legal regimes across the world vary greatly, and it may be difficult, and also in some cases impossible, for a blockchain to comply with the applicable laws in every jurisdiction in which it has a node. Hence, this proves the point that jurisdiction cannot simply be pinned based solely on the location of a single node, as it would create several disagreements on node-related international legal matters. Also, because neither Clevity nor both the parties are essentially DIFC entities or reside within the DIFC, the opt-in DIFC jurisdiction fails to apply to both parties and hence cannot govern this disputed trade. Thus, due to the aforementioned reasons, I urge the court to consider the lack of jurisdiction in this case and allow my client, Mr. Payne's appeal. Thank you.
Thank you, counsel. We will now proceed with the submission of the senior counsel for the respondent. Once ready, please proceed.
Yes, Your Honor. May it please the court, my name is Pal Jain and I appear as a senior respondent on behalf of the respondent. One second. May it please the court, my name is Pal Jain and I appear as a senior respondent on behalf of the respondent, Razrani, in these hearings with my learned junior, Ms. Shakira Zainab. If it pleases the court, may I proceed to state the facts?
Yes, please, counsel, but prior to doing so, can you kindly share the time that will be allocated to you and your co-counsel for submissions and rebuttal?
Your Honor, we'll divide 15 minutes each.
Thank you. And for rebuttal?
We'll keep 10 minutes for rebuttal.
So 5 minutes and 5 minutes.
Yes.
Or, all right. Thank you. You may proceed.
Thank you. Yeah. The appellant and the respondent are both users of the Clarity platform, a digital platform to trade in cryptocurrency. Owing to a system glitch brought on by a routine upgrade, the appellant and respondent were both the only users who could trade in the cryptocurrency Yapple. A disputed trade was committed between the parties at a price 250 times higher than the current market rate, for which the respondent brought proceedings against the appellant on the grounds that the trade is void for the unilateral mistake. The court of the first instance ruled in favor of the respondent, where the decision was then appealed by the appellant. In response to the submissions made to Your Honor by the appellant, I shall be addressing the first point of appeal through an essential submission opposing the appellant's views. I would like to direct Your Honor to paragraph 5, page 5, paragraph 8, namely that DFC has jurisdiction under Article 5A1B of the Judicial Authority Law. Thus, the appellant's continued performance is not justified. In this case, Your Honor, I would like to make a submission in response to the first ground of appeal, as previously stated, and this will place a greater emphasis on the factors asserting that as accurately determined by the Court of First Instance and Ms. Rani, the DFC Court has jurisdiction over the claim and was obligated to consider the claim and authorize an evaluation that the trade is void for unilateral mistake. If it may please the Court, I would like to proceed with my submission. Your Honor, I would like to proceed by stating that the Court of First Instance has exclusive jurisdiction as in Article 5A1B of the Judicial Authority Law, which indicates that claims arising in relation to a contract, whether partly or wholly concluded, finalized, or performed within the DFC comes under the jurisdiction of DFC. Additionally, the lex situs of a crypto asset is also considered when determining the jurisdiction of the claim. Thus, the appropriate jurisdiction of a valid claim is the place where the individual or the company who owns the asset is domiciled or where the damages have occurred as a result of the acts that were committed within the jurisdiction, as Your Honor noted in the case of Iron Sciences and Persons Unknown and others reported on 21 December 2020 Commercial Code, which can be found at page 21 of the Respondent's Code bundle. To support this argument, I would like to present the above case. Would Your Honor mention a brief summary of the Would Your Honor prefer a brief summary of the following case?
A brief summary would be useful. Thank you.
Thank you. Iron Sciences and its sole director, Duncan Johns, were victims of an alleged initial coin offering fraud, and they claimed to have transferred Bitcoin after they were convinced by unidentified parties that they were buying authentic cryptocurrency goods, only to learn that the recipient was a fraud. To protect the transferred Bitcoin, Iron Sciences and Mr. Johns applied for a proprietary injunction, a global freezing order against the unidentified parties, and a disclosure orders directed at the cryptocurrency exchanges in the form of a banker's trust order. The case's primary question was whether the court had jurisdiction in the application for interim relief and if the governing law of the claim was English law. The court referred to the analysis of Professor Andrew Dixon at page 23, paragraph 13, in determining that the lex situs of the cryptocurrency is the law which is applicable where the person or the company who rightfully owns the cryptocurrency is domiciled or has its registered office. In this case, it was the English law. The court concluded that the applicants had shown that there was a serious issue to be tried on the merits of their claims being brought or intimated in deceit, unlawful means conspiracy, and by the way of an equitable proprietary claim as highlighted on page 22, paragraph 13 in the Respondent's Code bundle. Furthermore, the proper jurisdiction for the trial of the claim was found to be England. The claim may have arisen from the events that occurred within the jurisdiction. The damage occurred within the jurisdiction. The applicants were domiciled in England, and the relevant funds and Bitcoin were based in England, allowing the applicant to satisfy the requirements of serving outside the jurisdiction, as highlighted on page 24, paragraph 16 in the Respondent's Code bundle. This is in accordance with the legal interpretation of Article 5 of the Judicial Authority Law, which states that the basic requirement to have a jurisdiction is to have a contract to be concluded or the acts taken under the contract to be performed wholly or in part within the DRC. The criteria is satisfied because Clevity functions using a distributed ledger and can be inferred from the contract between the users that a part of the business was run from DRC as one of the servers is located there. The lex situs of YAPL would thus be in DRC as it is the place where Clevity is domiciled partly. Your Honor, I would further like to emphasize the first ground of appeal made by the appellants regarding DRC having a jurisdiction over the claim, and the Court of Appeal should validate the decision reached by the Court of First Instance. According to the lex situs of the crypto asset, YAPL would be in DRC as one of the nodes of the platform is based in DRC, such that the damages have occurred as a result of the acts that were committed within the jurisdiction as well, and hence the decision of the Court of First Instance should be upheld. Your Honor, to highlight my viewpoint, I would like to present the case of Fetch AR Limited and another and persons unknown and others reported in 2021 Commercial Court of England and Wales High Court at page 2254 that can be found at page 25 of the Respondent's Court Bundle. Would Your Honor prefer a brief summary of the following case?
Yes, please.
An English firm, Fetch AR Limited, and a Singaporean company, Fetch AR Foundation Pte Limited, filed this lawsuit, alleging that the fraudsters had access to the first claimant's Binance accounts, which included a variety of cryptocurrencies. The perpetrators then traded these cryptocurrencies for amounts that were far below the market value in order to move them implicitly to their own wallets. This value drop was estimated to be about $2.6 million. Claims for confidentiality breaches, unjust enrichment, and an equitable proprietary claim based on unlawfully acquired property being held on a constructive trust were brought on by the claimant. The critical question in the case was whether England and Wales had the jurisdiction to hear the claim, where the cryptocurrencies did not belong to a specific place, and the claim was brought against unknown defendants. The court applying the Iron Science case was persuaded that there was a serious issue to be tried regarding whether the cryptocurrency is proprietary, is property, or a chosen action for the purposes of English law. The lex situs, which is the law of the place where the asset is situated or of a crypto asset, is a location where the person or the company who owns it is domiciled. The primary applicant and owner of the accounts were a resident of England, and the law of the place where the object of transaction is closely connected to applies. Therefore, the English courts had jurisdiction as highlighted at page 24, paragraph 13 of the court bundle. Your Honor, in the case mentioned above, it is evident that the damage has occurred as a result of the acts which were committed within the jurisdiction, and the relevant asset YAPL may be in DRC. Thus, the object of transaction YAPL is closely connected to DRC, with which the respondent satisfies the standards for serving outside the jurisdiction. With this, Your Honor, my submission is concluded. If Your Honor has no further questions, shall I proceed with my conclusion?
Please proceed, counsel.
In conclusion, Your Honor, the respondent contends that the judge of the court of first instance did not make an error in concluding that the DRC court had jurisdiction over the claim by the respondent against the appellant under Article 5A1B of the Judicial Authority Law, as Clevity operated a distributed ledger with a node in the DRC. Under the provisions of the DRC and the supporting case law, a cryptocurrency can be viewed as a property, and thus the lex situs of the crypto asset is similar to that of a physical asset. The lex situs of YAPL would thus be in DRC as it is the place where Clevity is domiciled partly. The case also has a serious issue to be tried on the merits of their claims being brought in, as it is addressing a claim of the trade being disputed for unilateral mistake. My learned junior, Ms. Shakira, will later address Your Honor to the second ground of appeal in response to the appellant's claim of the disputed trade not being void for unilateral mistake under Article 37(1)(a) of the DRC contract law. Unless I can be of any additional assistance, I bring my submissions to a close.
Thank you, counsel.
Thank you, Kanta.
Thank you.
Before we proceed
Now,
with, I'm sorry to interrupt, but before we proceed with the junior respondent, I just wanted to clarify that the rebuttal is from the appellant's side, isn't it?
yes, I was going to introduce you now. Yeah. Thank you for that, counsel. Yes.
No.
So, senior counsel for the appellant, once you're ready, please proceed with your rebuttal. Thank you.
Thank you very much. I would like to introduce only two submissions from my rebuttal. The first being, my learned respondent mentions the lex situs of the platform. However, it is nowhere mentioned in the facts of our current case that Clevity was established or domiciled in the DIFC or functioned partly or wholly in the DIFC. Moreover, the facts of the case do not mention where Clevity was domiciled or functions at all from any part of the world. Additionally, she mentions the distributed ledger with a node being present in the DIFC. It must be noted that a distributed ledger is nothing but can be used as an analogy to explain as being an online network server which merely stores information. So storing information on a distributed ledger's node can be done in any node in any part of the world. I would like to introduce an analogy. If two parties conclude a trade in Mexico and Brazil, the information of their trade can be stored on a node in Western Asia, for example, Turkmenistan. That does not apply Turkmenistan's jurisdiction over the trade conducted between the two parties. Secondly, I would like to mention Article 5A1, subsection B and subsection C of the Judicial Authority Law. It specifically mentions that a contract should be partly or wholly performed within the DIFC, or should be relating to DIFC activities, or should be about DIFC establishments. Since I've already proved that Clevity does not function in the DIFC because we have no proof or facts of our case to suggest that DIFC functions from the that Clevity functions from the DIFC, it cannot be concluded that Clevity is a DIFC establishment. Moreover, Ms. Razrani merely lives in Dubai and does not specifically live in the DIFC. Even if she were to use the opt-in jurisdiction of the DIFC, my client resides in the Sultanate of Oman, so that completely quashes the argument that this contract was partly or even wholly performed in the DIFC. That is all, Your Honor. Thank you very much.
Thank you, counsel. We will now proceed with the submission of the junior counsel for the appellant. Counsel, once you're ready, please proceed.
Good morning, and may it please the court. As introduced by my learned senior, Ms. Nabiha Khan, my name is Mr. Momin Khan, junior counsel for the appellant, Mr. Leith Payne. As stated by my learned senior, I will be addressing the second ground of appeal. For the benefit of the court, may I reiterate the ground of appeal and relevant facts that I will be contending with?
Yes, please. Yes, please.
Firstly, my client's argument. Mr. Payne argued that there could be no relevant mistake within Article 37 of the DIFC contract law. Mr. Payne said that even if Ms. Rani had made a mistake when he programmed Beta, he did not make the same mistake as Ms. Rani or cause her mistake, and he did not know and could not have known about Ms. Rani's mistake. And so there could be no grounds to avoid the disputed trade. Secondly, the court's assessment was that it did not need to examine the state of mind of the programmer when designing the program. It was held that in the court of first instance that it was sufficient that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that disputed trade was the result of an error. In reaching this conclusion, they cited Lord Mans from the case of Coin Private Limited and B2C2 Limited reported in the 2020 Singapore International Court of Appeal on page number 2. Your Honor, with these facts laid out, I will now begin my submission that the judge in the court of first instance erred in his application of law regarding Article 37(1)(a). Firstly, I would like to discuss the case of Coin Private Limited and B2C2 Limited reported in 2020 Singapore International Court of Appeal on page number 2 in 2 parts. The first being the arguments put forth by it, as the facts of it may be beneficial to our current situation, and second, Lord Mans's judgment as applied by the court of first instance. The facts of the case are quite similar, so may I reiterate them for the benefit of the court?
Very briefly.
Yes, okay. Coin Private Limited was a trading platform on which an error had occurred. This resulted in the algorithms of the parties involved, namely B2C2 Limited and others, concluding trades at a highly inflated price. The trading platform had reversed the trades after taking note of them and realizing that they were caused by an error on their platform. B2C2 Limited brought proceedings against them to recover the riches that they gained from the error on the grounds of breach of contract or breach of trust. Breach of trust is not relevant to my submission, so it will not be discussed, but the judge did rule in their favor. Coin filed an appeal, but their appeal was dismissed, leading to this case before the Singaporean Court of Appeal. The majority in this case ruled that when deterministic algorithms were doing the trading in respect of their programmers, the state of mind of the programmer must be analyzed from the creation of the algorithm until the conclusion of the contract in question. Mr. Payne's state of mind when designing beta could be subject to much speculation. However, it must be noted that when the programmers of B2C2 had designed their algorithm, they did not design it to benefit from volatile market conditions. The parameter to conclude a trade at an inflated price was to ensure that the algorithm did not break and stop working in extreme market conditions. It can be argued that this was Mr. Payne's intention as well, as he could not have realistically predicted an instability in the market that would have resulted in his benefit. If Mr. Payne did not become aware of this possibility at any time prior to the conclusion of the contract, there is nothing that can be said regarding his knowledge of the mistake. This conclusion means that Mr. Payne did not make the same mistake as Ms. Rani, as he was just trying to ensure the continuing function of his algorithm, and he could not have caused her mistake or known of the mistake, as the trade was concluded by deterministic algorithms in the complete absence of human input at the time of the formation of the contract. I would like to elaborate further on this point in my second submission regarding Coin. For my second submission regarding this case, I would like to bring to the court's attention that Lord Mance was providing a dissenting judgment, and his approach was criticized by the majority for a number of reasons. Firstly, Lord Mance's approach was scrutinized as being wholly artificial because it attempted to claim that the trade was concluded in a hypothetical on-the-floor meeting and not through pre-programmed algorithms, and that the final contract was entered into on terms that were not within the program parameters of the parties' algorithms. The majority in the Court of Appeal in this case argued that the parties had chosen to do their trading through algorithms, and it follows that any trades concluded by said algorithms would not be mistaken trades so long as they were concluded within the parameters set by the programmers. As I have already established, Mr. Payne did not know of or cause Ms. Rani's mistake in this case. The disputed trade was concluded by her algorithm within its preset parameters, and Mr. Payne's algorithm only sought to retain continuous function with its deep price parameter. It follows that the approach adopted by the majority should be considered more apt in this case. It is also important to note that the Singaporean court was applying the equitable doctrine of mistake at equity. No such approach exists in the English courts or the DIFC courts, and this statement can be supported by paragraph 90 of the Coin case found on page 238 to 239 of the appellant court bundle. For my second submission, I would like to bring to the court's attention the case of Smith and Hughes reported in volume 6 of the 1871 Queen's Bench Law Reports on page number 597. This case has provided a long-standing authority for the doctrine of unilateral mistake at common law and serves as a much stronger basis than the doctrine of unilateral mistake at equity. May I repeat the facts of this case for the benefit of the court?
Yes, thank you. Very briefly.
In this case, the defendant mistakenly assumed he was buying old oats from the claimant and refused the contract once he had realized the contract was for new oats. The plaintiff sued the defendant racehorse trainer for a breach of contract for the sale of oats. It was held that the unilateral mistake may only apply to the terms of a contract, and one party holding a mistaken belief is not enough to void a contract. Your Honor, as I have previously established, Mr. Payne did not make a mistake as to any terms of the contract, and he did not cause Ms. Rani to hold a mistaken belief that he intended to take advantage of. Ms. Rani held the mistaken belief that her algorithm would not lend itself to concluding a trade that would not be beneficial to her, and had taken no countermeasures to prevent such a situation. Mr. Payne, on the other hand, was aware of the fluctuations that occur every so often in the market and had taken preventative measures only to ensure that his algorithm would remain online and functional. There was no mistake here as to a fundamental term of a contract, only the mistaken belief of one party that there would never be an unfavorable market condition. It is my contention that under the doctrine of unilateral mistake recognized by the English courts, Mr. Payne should not be penalized for Ms. Rani's unpreparedness under the circumstances of this case. Through my previous two submissions, I have established that the mistake is no fault of Mr. Payne's. However, I would now like to submit that it is in fact Ms. Rani who is entirely at fault for the situation under DIFC contract law. I would like to bring to the court's attention the case of the Crown on the application of Software Solutions Partners Limited and Her Majesty's Commissioners for Customs and Excise reported on in the 2007 England and Wales High Court on page 971. May I state the facts of this case very briefly?
Yes, please. Thank you.
In this case, the claimants, Software Solutions Partners Limited, were providers of a program that allowed insurance brokers to expeditiously prepare insurance contracts with insurers. The program worked by accepting the input of parameters by the insurer and outputting a contract that fell within those pre-programmed parameters. It was held in the court that even in the event of a system error, the insurers would still be legally bound by the contract within limits, even if they were temporarily unaware of the resultant contract terms. This software was analogized with parking meters in Thornton and Shoe Lane Parking Limited, reported in Volume 2 of the 1971 Queen's Bench on page 163. The analogy I am referring to can be found in paragraph 66 of the Software Solutions Limited case judgment on page 128 of the appellant's court bundle. In that paragraph, the court accepted that such a software is similar to the parking meter in that case. As Lord Denning had so aptly put it, the customer pays his money and gets a ticket. It can be translated into offer and acceptance in this way. The offer is made when the proprietor of the machine holds it out as being ready to receive the money. The acceptance takes place when the customer puts his money into the slot. These situations are relevant to my client's appeal as the method of transactions are very similar. Mr. Payne had programmed his algorithm to sell Yapple at the best available market price, and in the event of there being no best available market price, at a highly inflated price to ensure it remains operational. Ms. Rani's algorithm bought Yapple at the best available price, and consequently, in this case, at the highly inflated price. Ms. Rani's algorithm works similarly to the way an insurer would input parameters into a program and be bound by the contract that was formed thereafter in Software Solutions Limited. She provided an input and she received an output. Even in the event of an error by her algorithm, she should be bound by the result as the insurers were in Software Solutions Limited. The end result still fell within the program parameters of her algorithm, so it cannot be said that this was a consequence that was entirely unforeseeable. Her input of parameters should indicate full acceptance of the offer made as they were in the ambit of her programming, similar to the case of Software Solutions Limited and the case of Thornton and Shoe Lane Parking. Bearing these facts in mind, I would like to make 2 points for my final submission, one statistical and one legal. Firstly, the manager and writer of the Quantified Strategies website, Odman Growit, penned an article titled "What Percentage of Trading is Algorithmic? Algo Trading Market Statistics, Growth, Trends, and Forecasts." In this article, he mentions that a study concluded in 2019 found that 92% of Forex market trading was done by algorithms and not humans. And according to Select USA, a federally backed United States summit held by the US Department of Commerce's International Trade Administration, it was found that around 60 to 75% of all US equity trading was carried out by algorithms. It is evident from these statistics that algorithmic trading is no recent phenomenon that took the world by storm. It is a well-established and practiced method of trading globally. With that said, I would like to establish the second part of my final submission by directing the court to DIFC Contract Law, Article 37, Section 2, Subsection B. The provision states that a party may not avoid the contract if the mistake relates to a matter in regard to which the risk of mistake was assumed or, having regard to the circumstances, should be borne by the mistaken party. Your Honor, I contend that with these statistics in mind, Ms. Rani should not be allowed to avoid the contract with Mr. Payne, as the risk should have been objectively in her reasonable contemplation, and as such is a risk that should be borne by her, the mistaken party. This concludes my submissions for the second round of appeal on behalf of Mr. Leith Payne. Your Honor, on these facts, I request that the decision of the Court of First Instance be overruled and the appeal be allowed. Thank you.
Thank you, counsel.
Thanks, counsel.
We will now proceed with the junior counsel for the respondent. Once you're ready, please proceed.
Yes, Your Honor. Your Honor, my name is Shakra Zainab, junior counsel for the respondent in this matter. I shall be dealing with ground 2 of this appeal, which states that the first instance did not err in concluding that the dispute trade between the respondent and the appellant was a result of an error. I shall, in support of this, make 2 submissions. First, a reasonable person should have known or ought to have known about the mistake. And second, one party is not allowed to take advantage of a mistake made by the other. If it pleases Your Honor, I will begin with my first submission. Article 37, Section 1, Part A of DIFC Contract Law on page number 8 states that the other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known of the mistake, and it was contrary to the reasonable commercial standards of fair dealings to leave the mistaken party in error. This article is based upon Article 3.5.1 of the Unidroit Principles of the International Commercial Contracts of the year 2004. on page number 98 to 99, which briefly explains the article. On page 100 of the Unidroit Principles, it mentions that the article indicates that the mistaken party may avoid the contract only if the other party satisfies of one of the four conditions laid down under Article 37, Section 1. The conditions are as follows. First, both parties labored under the same mistake. Second, the error of the mistaken party is caused by the other party. Third, the other party knew or ought to have known of the error of the mistaken party and that it was contrary to the reasonable commercial standards of fair dealings to leave the mistaken party in error. And lastly, the party other than the mistaken party had not reasonably acted in reliance on the contract up to the time of avoidance. Your Honor, the third out of the four conditions may satisfy the grounds as reasonable test must be taken to determine if the appellant have ought to know the mistake. I'll be referring Your Honor to the case Trey King Kong and others and digilandmail.com Private Limited reported in the second volume of the law report of the Commonwealth in 2005 on page 28. Your Honor, for further guidance, I would like to direct you to the page number 7, paragraph 18, 19, and 20 of the skeleton argument in the Respondent's Court Bundle. For further judgment on the case, I would like to guide Your Honor by clicking on the case name in the index on page number 1 in the Respondent's Court Bundle. For the benefit of Your Honor, may I reiterate the case of the facts of the case?
Yes, please.
Please.
Yes. In this case, the respondent, digilandmail.com Private Limited, was an online IT company that sold related softwares and hardwares from Singapore. They were selling an HP laser printer and an employee accidentally made a mistake as to the price of the printer on their website. It was listed at the price of $66 when it was advertised on the HP website for $3,854. This was not noticed by the company until over 4,000 printers were ordered. The appellant had ordered over 100 printers, each at this price. When the respondents discovered this mistake on their website, they sent an email to the appellant to say they would not be fulfilling this order. The courts have stated in the Gilan case that regarding the reasonable test in paragraph 37, that if a party ought to have realized the mistake in the light of the surrounding circumstances, that will be classified as actual knowledge within the extended definition of willfully shutting one's eyes to the obvious. In the light of circumstances, the appellant did agree that there might be a mistake when said, even if Ms. Razi made a mistake. When mentioning Ms. Razi's mistake, the appellant willfully shut his eyes from the possibility of a mistake being present in the disputed trade. Following this, the courts of Digiland Mail had also mentioned in paragraph 35 that phrases such as must have known and could not reasonably have supposed are evidential factors to find whether the non-mistaken party did in fact know of the error made by the mistaken party. Furthermore, Your Honor, I would like to draw your attention towards paragraph 38 of Digiland Mail case on page number 17 of the Respondent's Court Bundle. The Court of Digiland case cites the High Court of the same case, stating that a reasonable man would harbor a real suspicion that the price may not be correct or that there may be some troubling underlying basis of such a price. In our case, when the disputed trade was concluded at a price 250 times greater than the prevailing market price, the appellant ought to have known that the trade was a mistake. In conclusion, under the reasonable man's test, the appellant ought to know the mistake when the error occurred. If Your Honor has no further questions, may I move on to my second submission?
You may, yes, thank you.
Yes, Your Honor, thank you. My second submission is as follows. One party is not allowed to take advantage of a mistake made by the other. I'll be referring Your Honor to the case of Hartog and Collins and Shield, reported in the third volume of All England Law Reports on page number 566. Your Honor, for further guidance, I would like you to direct to page number 8, paragraph 22 of the skeleton argument in the court bundle. For further judgment on this case, I would like to guide Your Honor by clicking on the case name in the index on page number 1. For the benefit of Your Honor, may I briefly state the facts of the case?
Yes, please.
The defendant contracted to sell 30,000 Argentine hair skins to the plaintiff, but an alleged mistake, they offered goods at certain prices per pound instead of price per pieces, which was approximately one-third that of a pound. In verbal and written negotiation, which took place before the sale, references had always been made to the price per piece and never to the price per pound. And expert evidence was given that the Argentine hair skins were generally sold at prices per piece. Judge Singleton of the Hartog case from the Hartog case stated that the defendant knew about the mistake and took advantage of the claimant. In other words, realizing that there was a mistake, the plaintiff did what is described as snapping up the offer. This can be applied to our case as the appellant ought to know there is a mistake because of the absurd fluctuation of the price and took that advantage as he's getting $250,000 out of my client's bank account. If Your Honor has no further questions, I will be moving on to my conclusion.
Yeah, please do.
On this ground and previous ground given by my learned senior, it is accordingly submitted that Your Honor should dismiss the appeal and conclude that the Court of First Instance did not make any error in concluding that the DIFC Court had jurisdiction over the claim by the respondents against the appellant under Article 5A1B of the Judicial Authority Law, and that a reasonable trader would have known the disputed trade was a result from an error which is in line with the previous decision reached. Unless I can further assist the court, my submissions are complete.
Thank you, counsel.
Thank you, counsel. We will now proceed with the junior counsel for the appellant's rebuttal.
Yes, Your Honor. So I believe that my submission covered most of what the respondent counsel argued. However, I would like to bring to the court's attention that, as I've stated in my arguments, Ms. Rani held a mistaken belief as to the market, not to the price of the disputed trade. Furthermore, the respondent counsel's argument attempts to make the same mistake as Lord Vance's dissenting argument by recasting the matrix of the facts to suit a hypothetical on-the-floor meeting. As we know in this case, the deterministic algorithms of the parties concluded the contract. There was no human input from them at the time of conclusion, and there might not have been any human input from them besides when the algorithms were created. This situation happened entirely in the absence of human input. Secondly, Digital and Mall is also a Singaporean case, just like Coin and B2C2 Limited, that applies a doctrine of unilateral mistaken equity. This is a doctrine that has been entirely removed from the English courts and is not present in the DIFC courts to my knowledge. Many English authorities also dispute the validity of this approach, which can be found on page 238 to 239 of the appellant court bundle, in a paragraph in which it says, the English authorities, it seems to suggest on balance, that there is no equitable jurisdiction to vitiate a contract for unilateral mistake, and if there were, they appear to doubt whether it extends beyond a mistake as to a term of the contract. And there are many sources, case law authorities, etc., which hold this belief. That is all. Thank you.
Thank you, counsel. Thank you, everyone, and well done. Fellow Judge Singh, do you have any comments for the counsels?
No, I'd just like to congratulate both all the speakers, all the counsels. I think it was very well argued and very coherent. Yeah, I did have a general question, but I think the judges can discuss that separately.
Okay, thank you. Thank you, everyone, and well done, and have a great day. All the best. All the best.
May I ask a question?
Sure. Sure.
So as this was our the last round of the 4 preliminary rounds for my team, will we be receiving any email regarding progression into the next rounds or anything regarding how we scored on each of the performances in the rounds?
I'm not sure with regards to the admin. However, perhaps we talk to organizing committee.
Okay, all right, thank you.
Yeah, we will give you some communication, will be sent out via email. So just watch out for that. You'll get some communication.
All right, perfect, thank you.
Thank you, guys.
Thank you.
Thank you.
Thanks, everyone.